Hello. Today we're going to be talking about the subject that driver's license restoration is counterintuitive, which is Chapter 7 in the book Get Your Michigan Driver's License Back, which I wrote with attorney Matthew Zick. It is important to realize that what you may think is presenting a good case is not necessarily beneficial to you when you go for your hearing at the Secretary of State, or even when you go for the evaluation. There's a tendency to think that when you're in a legal situation, you want to minimize the severity of the problem. You want to convince the judge or the jury, as the case may be, that you really aren't a bad person and that whatever it was that you were charged with was an aberration, not something that is a normal part of your behavior. And it makes sense intuitively to take this approach in most legal proceedings. However, this is not helpful in the case of driver license restoration, because the hearing officer already believes that you have a problem, or you wouldn't be sitting in front of him. You have 2 or 3 DUIs, maybe some other offenses, and he's pretty sure that you have a substance abuse problem, and to try to argue that you don't have one is really going to sound like denial. It's not going to sound like somebody is owning the problem and is willing to do whatever is necessary to solve the problem. So you want to avoid the argument that I wasn't that bad. And you certainly don't want to give the impression that you think that you can handle alcohol at this point or at any point in the future. He is more likely, or she is more likely, to grant you a license if they are pretty confident that you get the message that any degree of loss of control is a problem, and that you would be better off not to imbibe alcohol at all, because once you start drinking, your judgment might be impaired and you might again get behind the wheel and present a danger to yourself or others. We often read other therapists' reports, and many therapists seem to be of the same delusion as their clients, which is that the client will be benefited by minimizing the degree of their problem with alcohol. And so they will indicate that somebody has a alcohol abuse problem rather than alcohol dependence, and essentially try to put the client in a good light by indicating that he didn't have a serious problem. Again, the evaluators that do this are probably not helping their clients. They're not helping their own credibility with the hearing officer, who wants to know that the evaluator gets the seriousness of the problem, and if the evaluator isn't getting it, then maybe he's not qualified to do the evaluation, or maybe the client is just not being honest with him. It's really important to delve into the severity of the problem, and one of the things that hearing officers will look into, and it is now part of the evaluation, is not only have you used alcohol or been arrested for drinking and driving, but what other substances has the client used or had a problem with that will or could potentially lead back to a relapse into active drinking, or a problem with driving on another substance such as an opiate or benzodiazepine. They really don't like to see this use of substances, but especially they don't like to see it not addressed. So if you, the client, or if you're an attorney, your client is not addressing the issues of other substance use, it's important that I, the evaluator, look into that, and I will ask you questions about it. And if you don't answer the same way to me as you answer to the hearing officer, then you're going to have a problem. And all of these things basically come out of the desire to put yourself in the best possible light. But I always tell my clients, you're better to throw yourself on your sword, admit that you have a problem, and then go on to talk about your solution. I give my clients plenty of chance to talk about all the things that they're doing right in the prognosis section of the evaluation, which is why my evaluations are 6 pages plus a 1-page drug screen, as opposed to the 2 pages that the form the Secretary of State sends out has. It allows you to talk about all of the things that you've done right since discovering that you had a problem. But to say you didn't have that problem is more likely to give the message to the hearing officer that I don't have a problem, therefore how can I possibly have a solution? It's important to give the hearing officer 2 messages, in my opinion, in most cases, with very few exceptions. And again, these exceptions are so rare that it's better not to even talk about them because you're not going to be thought of as the exception. But you need to be able to acknowledge any problem that you have with alcohol and or drug abuse and show the hearing officer that you clearly own that problem, that you know that you cannot use any substance in any quantity, period. And then the second point that you have to make is that you are doing whatever is necessary in your particular case to make sure that you will not drink or drug again. And that may be going to a 12-step meeting on a regular basis, working the 12 steps, having a sponsor, all of the traditional ways in which addiction can be arrested, or it may be more untraditional ways, such as involvement in church, close family ties, replacing the negative activities of abusing substances with more positive activities, going to the gym, losing weight, exercising, hiking, rock climbing, whatever it may be, running marathons. I've had clients that did all of the above. And it is really important to show that you have turned that corner. You can make that case by letting them know what kind of progress you've made financially, educationally, in your career, in your relationships with other people. There's plenty of opportunity to make that case that you are doing what you need to do and that the results are evident. But you cannot make that case if you downplay the seriousness of the case or the seriousness of the substance abuse. And I've had clients come in and tell me that they didn't see it as a problem if they have an occasional beer or an occasional couple beers. There's nothing I can do in that situation other than saying that this person does not think he has a problem and does not think he has to obey the law. And it is law that you must have at least a year of sobriety before you can get your license back. There's no way that the hearing officer is going to ignore that law or put you above the law. And if you try to put yourself above the law, you're really defeating your own purpose. So the AA people usually don't have as much of a problem with this as people who are not in AA. Because AA people know that they have to admit in the first step that they're powerless over alcohol or drugs and that their life's unmanageable. But it's people who have gotten sober through other means who often have trouble with the idea of admitting that it's a problem. If they're, say born-again Christians, they may feel that they've been relieved of that burden. That's all well and good, but the hearing officer needs to know that you do not feel at this point in time that being relieved of the burden of addiction means that you can go back and use it in small quantities at some point in the future. It's especially important also that legal counsel advises their clients prior to going to the substance abuse hearing that it will not benefit them to minimize the problem. It's very important that you take full ownership of the problem, and you have to address this with your clients, because if they go into the hearing in a defensive mode, then they're not going to do well. So I've heard attorneys talk about a come to Jesus meeting with their clients, and what this really means is taking ownership of the problem and essentially putting yourself at the mercy of the court. And in this case especially, you have already been convicted. The appeal process requires clear and convincing evidence that there's been a change in your behavior and in your ways that's sufficient to give him confidence that you will not drink or do drugs again. And if you can do this, you have a good chance of getting your license back, usually a restricted license for the first year with a breathalyzer, and if you're successful at that, then you can get your full license back, and provided you don't drink or abuse drugs again in the future, you'll never have this problem again. Thank you.